All right. So, you've been thinking about all this stuff out there about you online, and you found some interesting things from a law firm, MCHM Abogados.
Mm-hmm.
And it looks like they're based in Almeria, Spain.
Okay.
And they do work for all kinds of clients,
Right.
Individuals, big companies, even public organizations.
Yeah.
And they're all about being really committed and efficient and excellent at what they do.
Sounds good.
So what we're going to really dig into today is this thing you might have heard about the right to be forgotten online.
Yeah, that's right.
So,
It's about you being able to ask for your personal information to be taken off the internet.
okay.
And often when we first talk about this, we're thinking about getting stuff off search engines
Right.
like Google.
Right.
So we really want to explore how that works and how you might go about using it. And just as importantly, where the limits are on it.
Okay.
So you can come away feeling knowledgeable and in control.
So this whole idea of a right to be forgotten,
Yeah.
I mean, it feels pretty important in today's world.
Mm.
Where did it even come from?
Well, it kind of grew out of this really fundamental need to protect individual privacy and reputation in a digital age, right? I mean, think about the scale of the internet.
Right.
It's this almost limitless capacity to store and share information.
Yeah.
Practically forever.
Forever, yeah.
And that created a real tension with how we traditionally thought about privacy.
Mm-hmm.
This idea that things from the past might naturally fade from view over time.
Yeah, that's a really good point. Like before the internet, if something happened, it might be tucked away in some archive somewhere.
Exactly.
Now it can pop up instantly in a search result
Right.
years later.
Exactly. And a real turning point, I think, was the 2014 decision by the Court of Justice of the European Union.
Okay.
And that ruling basically said that search engines have a responsibility when they process personal data
Okay.
to follow data protection rules.
So that was a pretty pivotal moment specifically for the right to be forgotten in relation to search engines.
Absolutely. And then a few years later, in 2018, the General Data Protection Regulation, or GDPR, came into effect.
GDPR.
Exactly.
Yeah.
And this really expanded the reach of this,
Right, okay.
It wasn't just about search engines anymore. The GDPR gives individuals the right to ask for their personal data to be erased in pretty much any digital context.
Wow.
What's so interesting here is how this seemingly very specific ruling became a much broader principle.
So that's a huge shift.
Yeah.
So I'm listening to this and I'm thinking, okay, this is relevant to me. How do I actually try to use this, right?
Right.
What are the practical steps?
Well, the first step, and this is really crucial, is identification.
Okay.
You need to really pinpoint the specific information that you want removed.
Mm-hmm.
And this could be on search engines like Google, but it might also be on social media platforms or even on specific websites.
Okay.
It's a good idea to do a really thorough search using your name and any relevant keywords just to make sure you found everything.
Okay, so first got to find it.
Find it, yeah.
Makes sense.
And then the second step is direct outreach.
Okay.
Once you've located this information, you're going to have to contact the service provider directly, whether that's the search engine, the social media platform, or the owner of the website.
Okay.
And the interesting thing is a lot of the major players, like Google, have actually set up specific forms and procedures for these kinds of removal requests.
Wow.
You can usually find them on their privacy or help pages.
So track it down, find the form, fill it in.
Yep.
Is that pretty much the gist?
Well, not quite.
Okay.
The third step, and this is really critical, is providing justification.
Okay.
You need to give really clear and valid reasons for why you're asking for the information to be removed. The provider isn't just going to take your request at face value.
What sort of reasons would they consider valid?
Well, the material you sent me had some good examples. Things like the content being factually wrong.
Okay.
Or maybe it was accurate at one time, but it's no longer relevant to your current situation. Another reason could be that the information doesn't really serve any public interest.
Okay.
And it's negatively impacting your private life or your reputation. And so then the provider will weigh your justification against their own policies and any legal obligations they have.
Okay.
And this raises an interesting question. How do these providers determine what's a valid reason and what isn't?
Yeah, I mean, it sounds like there's a bit of a judgment call on their part.
Yeah.
Balancing individual rights with like the broader need for people to have access to information.
Exactly.
So you found the content, contacted the provider, explain why you want it gone. What's the final stage?
Well, the fourth step is all about follow-up and being prepared for the outcome.
Okay.
You need to keep track of your request and be ready to provide any additional information the provider might need.
Okay.
It's not always a quick process.
Right.
And responses can vary.
Okay.
And importantly, you should be aware that if your initial request is denied, you might need to consider legal action.
Oh, wow.
If you want to pursue it further.
Okay.
So the initial request isn't always the end of the story.
So it could potentially involve more than just filling out an online form.
Yeah.
Okay, this right to be forgotten sounds pretty powerful.
Yeah.
But the material you sent over also really emphasizes that it's got its limits.
Yes.
Where do those boundaries typically lie?
Yeah, well, that's a crucial part to understand.
Yeah.
It is a significant right,
Okay.
but it's not an absolute right to have everything online about you just disappear.
All right.
It has to be balanced against other really important fundamental rights, like freedom of expression and the right of the public to access information.
Yeah, that makes sense. You can't just demand the removal of, like, accurate news reporting.
Exactly.
Right.
One of the key limitations really centers around this concept of public interest.
Okay.
So if the information has genuine public relevance,
Yeah.
for example, information about the criminal records of public officials,
Right.
or details concerning their significant professional activities, search engines are very likely to refuse removal requests. The rationale here is that the public has a legitimate need to know this kind of information.
Right.
What's interesting here is how the definition of public interest can be interpreted differently in different situations.
So the need for transparency and accountability for people in the public eye can outweigh an individual's request to be forgotten.
Exactly. And another set of limitations come from legal obligations.
Okay.
Sometimes information just has to stay accessible because there are legal requirements mandating that it be retained, or because it's considered to be in the broader public interest,
Okay.
particularly in areas like public health or public safety.
Right.
So if we connect this to the bigger picture, you can see how different societal values come into play.
So like a public health organization wouldn't be able to erase information about a disease outbreak,
Right.
even if individuals wanted their names taken off related records.
Oh, right.
Okay.
And then we also have exceptions made for research and archiving purposes.
Okay.
So information can be kept if it's for public interest, archiving scientific research or historical documentation. The underlying principle here is the preservation of knowledge and historical records for the benefit of society.
That's really important for societal memory and progress.
Absolutely. And finally, the material you sent pointed out that the public nature of judicial decisions can also take precedence over the right to be forgotten. Court rulings, especially those that are meant to be disseminated publicly as part of a fair legal process.
Right. Generally need to remain accessible. So if a court case is a matter of public record, you can't just ask Google to get rid of mentions of it in search results?
That's the general principle.
Okay.
The legal system prioritizes transparency in these matters.
Yeah.
So this raises an interesting question. How does the right to be forgotten interact with the principles of open justice?
This has been so helpful in understanding all the nuances here and all this balancing act involved. So for you, our listener, as you're going about the digital world, why is it so important to understand these procedures and limitations?
Well, it really boils down to being able to effectively manage your online presence and safeguard your privacy in today's hyper-connected world. So by knowing your rights, understanding the process for potentially using them and being aware of the limitations, you're empowered to take as much control as possible over your digital footprint within the existing legal framework. What's fascinating is how much individual responsibility there is in this process.
Yeah, absolutely. It's not about completely erasing history, but about having some degree of control over how your personal information is presented and accessed online, while still respecting these broader principles of freedom of information and the public interest. So it's a real balancing act.
Exactly.
So let's do a quick recap of the key takeaways from our deep dive into the right to be forgotten, drawing on what we've learned from MCHM Abogados.
Sounds good.
We've explored its origins, rooted in the need for digital privacy and evolving through really significant legal milestones, like the 2014 CJEU ruling and the GDPR.
Exactly.
We then walked through the practical steps involved in maybe using this right,
Yep.
identifying the specific content directly contacting the service provider, clearly explaining why you're asking for it to be removed. For valid reasons, of course.
Of course.
And diligently following up while being aware that you might have to pursue other legal avenues. And finally, we looked at some of the important limitations around information that's in the public interest, legal obligations, the need for research and archiving, and the public nature of judicial decisions.
That's a really good summary.
So
it's about knowing this right exists.
Yeah.
Knowing the steps to use it, but also being realistic about when it can and cannot be applied.
Yeah. And as we bring this deep dive to a close, here's a final thought for you to consider. Given this delicate balance between an individual's right to privacy and the public's right to know, how do you think the right to be forgotten will evolve in our increasingly digital society? It's a question without easy answers, but one that's becoming more and more relevant as our lives get more and more intertwined with the online world.
Absolutely.
Thanks for diving deep with us.
My pleasure.